Members, this is the 9th meeting of the Interception of Communications and Surveillance Amendment Bill, Bills Committee meeting 2015. And this is the appointed time, and we have a quorum, so let's give a start. And we have a team of government officials attending the meeting today who have been here in previous meetings, and they are Ms. Mimi Lee, Deputy Secretary for Security, Mrs. Millie Ng, Principal Assistant Secretary for Security, Mr. Chiu Man Hin, Assistant Secretary for Security, and from the Department of Justice, Mr. Godfrey Ken, Senior Assistant Solicitor General, and Ms. Monica Law, Senior Assistant Law Draftsman. So, welcome. At the last meeting held on the 14th of July, well, that's been some time since the last meeting, and the government has prepared a response to issues raised at the last meeting, which can be found in paper CB bracket 22152/1415 bracket 01. Which is a paper to put down their response to the issues raised by us in writing. So, moving on, let's continue with the clause-by-clause scrutiny work last time, and let's look at page 4 of the markup copy. Page 4, point number 3, conditions for issue, renewal, or continuance of prescribed authorization. So, Mrs. Ng, over to you, please. Yes? Are we not going to discuss the paper? This is just a paper of response to issues raised at the last meeting. But I have questions to ask. Well, perhaps we should start with the clause by clause first. But they have to do with the definitions discussed. So on this point, Mr. James To, well, if you want to discuss the paper, then I'll give you time to discuss it. But I think we spent quite some time on the same issue at previous meetings. But that's because these issues were identified in the previous discussions, and I need to ask some follow-up questions. All right, then, if members agree to this member's suggestion, then perhaps we can now refer to this paper, the latest one. A paper of our Bills Committee, CB bracket 22152/1415 bracket 01. So what question do you have, Mr. James To? Paragraph 3. Now, say, for example, if it's in a language that they're not provisioned in, then can an officer entrust another officer or a non-officer to provide translation services? Let's say if it's in a language that they're not proficient in, then can the officer commission someone who is not a public officer to do the translation work? According to the government's response, it says, I'm looking at line 6, then all such powers shall be deemed to be also conferred as reasonably necessary to enable the person to do or enforce doing of the act. But we must bear in mind that this is about conferring power to that person, not any person. So in other words, if somebody who is not an officer, if somebody is not a public officer, then then the person should not be allowed to gain access to the products, the Intercept products. So I have a question for the legal advisor. Perhaps the government could also twist the argument to suggest that it is possible. But my question for the legal advisor is that it should not enable the person to do so. Legal advisor, your take? Of course, the government can supplement. In the government's paper, paragraph 3, apart from relying on Section 40 of Cap 1, the IGCO, they also rely on Section 30 of the ICSO in coming up with their analysis. So perhaps the government can give us more details of that analysis? Yes? Thank you, Chairman. Thank you, Mr. James Toh. We share the same view of the legal advisors, and that is why we have set out the relevant provisions. Under Section 40 of Cap 1 IGCO, our interpretation is this: where any ordinance confers upon any person power to do or enforce the doing of any act or thing, all such powers shall be deemed to be also conferred as are reasonably necessary, and by reasonably necessary we interpret it as a necessity to empower somebody to do the translation work. And it should be read together with Section 30 of the ICSO, which provides that a prescribed authorization also, or no public officer shall, direct or indirectly, carry out any interception unless the interception is carried out pursuant to a prescribed authorization. And that is why, when the power is exercised under Section 40, it should be carried out pursuant to a prescribed authorization. That is to say, with a prescribed authorization, where necessary, a translator's assistance can be sought. And in covert operations carried out after enactment of this ordinance, there haven't been many cases in which translation is necessary. And where it was necessary, we tried our best to ask translators in the civil service to help. I'm not talking about trying our best, because if you say that you're going to just try your best, then you can also have the work outsourced. Does it mean that, by analogy, when you don't have enough manpower, you can outsource your work to private detectives? Is it possible if Section 30 is construed this way? Yes. Can it be construed that way? Chairman, in various covert operations, there may be different circumstances with different needs. The principle is that we should use as few so-called outsiders and outside translators as we can. And we have the legal framework, and justification is necessary. Now, for the sake of argument, the scope is so wide that the work can be outsourced, and we have no idea how many non-public officers can have access to that. Well, yes, Section 30 is in relation to the assistance provided for the enforcement of that provision. So Mr. James Toh was talking about engaging private detectives and having the work outsourced. So can this section be construed as possible? Well, as I explained, if there are no suitable translators within the government, or within the department, in terms of enforcement, it is necessary to engage somebody outside. But of course, we have the certain confidentiality arrangements. Legal advisor. Well, I stand to be corrected, but I understand that the policy intent is that where necessary, if the communications intercepted are of a language that the relevant enforcement officers are not proficient in, then it may be necessary to engage the help of translators. So let me give you another point to consider. Let's say in carrying out certain duties related to the covert operation, that is to exercise the writ, then there is a similar provision. Where necessary, assistance can be given to a public officer, but will they consider expressly provide such powers?
Ms. Lee, thank you. Under Section 30G of the ordinance, it is said that prescribed authorization will include a prescribed authorization also authorizes the undertaking of conduct that is necessary for and incidental to the carrying out of what's authorized to be carried out under the authorization, including the provision of assistance for the execution of the authorization. If you want us to make it more explicit in the ordinance, we can think about it. Ms. Claudia Mo, I do understand that under different circumstances there may be different needs. But time and again, we've mentioned the translation of language. Now, there will be no objection to the employment of a translator when we deal with ordinary cases. But Mr. James Doe is talking about the employment of a private agent. No, she didn't say that it was okay. So I think it's rather ugly if you outsource legal enforcement work. So, apart from translation services, what other services would you need? Under what circumstances will you need people who are non-public officers to render assistance? Now, if you just talk about translation of languages, perhaps you should expressly say here that officers who are required to render translation services. Ms. Lee, in a genuine covert operation, we will not employ a private agent. It is not possible because interception can only be done by a public officer. In the process, he can seek the assistance of other persons to overcome a language barrier. It's just like what we said in the last three sentences in paragraph 3. Now, for the police, which is a large LEA, it has got a pool of translators with proper records and also their track record. So usually they will be considered as a priority. So can't you specify here to render assistance in translation services? So Ms. Mo asked whether you can specify it in the bill. We believe it is not necessary because interception of communications can only be done by public officers under the ordinance. Given the case, we have no intention to amend the provisions here. I'd like to ask our legal advisor's view, whether he concurs. Allow the Deputy Secretary to finish first before I defer to the legal advisor. DS, you were saying? Yes, I'd like to supplement one point. When there is a the need for translation, it must be a rather special case, because usually the IEAs will be able to tackle different languages if in the unusual circumstance that a translator is needed. The commissioner will be aware of it, and I think he will gatekeep to see whether there is any irregularity in the case. Legal advisor, as mentioned, we'll talk about Section 40 of the IGCS and Section 30 of the Interception of Communications Ordinance. And as the DS pointed out, Section 30G is relevant. It talks about the prescribed authorization and the scope of authorization. It includes conduct that is necessary for and incidental to the carrying out of what is authorized to be carried out under the authorization, including the provision of assistance. So the prescribed authorization would include all that is necessary and incidental. But there is no mention of the kind of persons that can be authorized. So under some circumstances, other persons may be called in to render assistance. So superficially, Section 30 is silent on people who can provide assistance, but the prescribed authorization authorizes also the undertaking of conduct that is necessary and incidental to the carrying out of what is authorized, though there is no express mention of the persons that can be called in to render assistance. Let's set aside the IGC ordinance first. Now, Section 30 of the ICSO is about authorization of undertaking of conduct that is necessary for an incidental. Now, we'll just talk about a translator is different. Now, for instance, the volume of the intercepted product is very low, and you have to amplify the sound. Amplification may be regarded as a conduct that is incidental, and maybe in the police there is no technician that can do it. So you ask another technician not to listen to the product, but just to amplify the sound product. Now, if in another case, you have a language that you don't understand, you have to ask a translator to listen to the intercepted product. So you say that there's already authorization. Now, there was a heated argument on whether a judge could listen to the intercepted product, but here, for the sake of translation, an other person can do so. The interpretation of the clause in this way is rather strange. And how come a translator is allowed to listen to the product, whereas for stalking or for tracing after some person, for surveillance purpose? Well, you may just ask one police officer to supervise 10 private detectives. Is that possible? Is that allowed? Would that be regarded as a conduct that is necessary and incidental? Well, you talked about thinking about it, but the interpretation of the clause is so wide that we don't know how to monitor. And you have to bear in mind that even the report by the Commission made no mention of such conduct. So how many non-public officers have already got access to such products? So on this, it's not just the translator that is in question. Now, for a locksmith and for a technician to tow the car away, I fully understand when you want to gain access to premises, you can just prise open the door, but if you don't want to damage the lock, you ask a locksmith to do it. But that is already an overt conduct. Now we'll talk about covert operation here. You say that it is so covert, and yet there are some of the people who can have access to the products, and you claim that they have frequent cooperation with the LEAs, and we allow the translator to listen to the full product, or will you ask different translators to listen to separate segments so as to ensure that no one single translator can listen to the full version? So will you have such mitigation measures? How can you ensure confidentiality of these products? Because we are not very confident about our ability to monitor the conduct of non-public officers. I think the scope is very narrow. No. You look at the heading. So do you agree that translators can be used? And yet the question is how you can check the power or the authority of the translators. Well, I'm talking about the clause, but the clause is already here. You have to bear in mind that we might not be so conscious of this clause or section when it was first vetted. No, we cannot just accept their answer as such. They should come back and tell us how they can enhance public confidence in their own system. Yes, I agree that the employment of a translator is reasonable. You can't expect a police officer to understand a language strange to him, but the question is how you can have a safe and sound framework to make this possible. All right, now I understand your concern. So Mr. To thinks that it is reasonable to employ a translator, but since the section has been in place for a while, in fact, this is not included in the current bill. So, DS, what do you intend to do? Only crimes that may attract imprisonment of at least 7 years can allow interception of communications. So if we talk about a very serious crime affecting public safety, then even if the assistance of translators is needed, well, it is a very common phenomenon in the investigation or enforcement of the law. For usual languages that can be tackled within the police force, but if the language is uncommon, then outsiders may have to be employed. Yes, even law enforcers are very worried that the confidentiality may be compromised, so they will have measures to ensure that these translators will only have access to what they need to listen to give them assistance. So they have this arrangement of compartmentalization, where they even do so for deployment, internal deployment of staff to ensure confidentiality. We're grateful to the chairman and Mr. James So's views. We believe Section 30 is clear enough, and we understand that the assistance can include that from a technician. And if you want clearer guidelines, we can do so through the code of practice. Because once the bill is enacted, we'll consider how the code of practice should be amended. Mr. Sin Chung Ka, my question relates to the request for LEAs to maintain statistics for the coming 3 months on respective numbers of approved and rejected applications. Now, according to the reply, this is irrelevant to the bill, but I don't find this answer acceptable because times have changed. 10 years ago, the internet was not too common. Of course, they would have to do bugging, but now sensitive information or secrets can be found on the net. So the spirit of the bill is to monitor how the administration has access to such information. The last meeting was held on the 14th of July. Now it's already the 10th of October. So you said that you didn't keep such statistics. So in July we told you that we would go into the summer recess and you should have enough time to collect statistics. But I think you're fully uncooperative. You just refuse to give us any information.
Well, according to their answer, they believe that this will be disproportionate in terms of the limited resources and the work required. Well, Chairman, I don't want them to continue to tell lies. Objectively speaking, how would one say that because of limited resources they can't do it? You can just ask several clerical staff members to do the count. Or perhaps I can just take a few days off and do the counting in law courts. Yes? Have you lied? No, Chairman, I haven't. We're talking about regulating covert operations by this bill. The court will be the gatekeeper. And we're not talking about protected products in covert operations. So when we say that it's not relevant to this part, well, we understand Mr. James Toh and the other members' concern over this, and that is why we have set out in great detail the whole procedure involved. It's not the case that we refuse to disclose any information. We just believe that it may be more appropriate to discuss this on another occasion. It will be more constructive to do so. But we understand the members' concern. I recall that Mr. Sin first raised this issue during the first and second meetings as to whether some LEA officers would circumvent the ICSO for the sake of convenience. I want to emphasize, finally, that when investigating into a case, it may be necessary for us to collect intelligence or to further our investigation by intercepting communications. But towards the final stage of investigation, we would try to keep our investigation open and apply to courts for warrants. I really find it hard to swallow because I honestly cannot agree with you, because times have changed and we're talking about a treasure trove of information. I'm asking for an analysis of these statistics, and yet you refuse to do so. I'm not talking about the actual products, I'm only asking for figures, the breakdown of statistics, and you still refuse to give me this information. And in fact, I could have taken a couple of days off and done it for you. So you can't answer by saying that this is not related to this bill. The purpose of this bill is to oversee the work of the law enforcement agencies in whether they extract information in an improper way. Well, I think we have gone through this point not only at this meeting but in previous meetings of this Bills Committee. I think the views have clearly been expressed, and I'll see if the government has anything else to add. If not, I will allow another member to carry on. Anything to add? Yes? No? Mr. Denscott. Well, I raised the same point in the previous meeting. It's impossible to say that this is not related to the bill. Times have changed, the technology has evolved, so if the LEAs seeks to obtain information from ISPs, they can circumvent the ordinance. We need to ensure that the constitutional right of our people will not be undermined. Over the past 2 months, my assistants and myself thought hard on how to improve this bill, and we have prepared some CSAs which can be circulated to members. We're not talking about major amendments. Only minor amendments will do. Will achieve what we want. So if necessary, I can circulate the draft to members. Thank you, Chairman. Anything to add? Yes? Well, Chairman, let me add that it'd be best if the government review the bill and come up with CSAs instead of letting us do the job. It will be more effective. Well, can you tell us what your CSAs will be about? Apart from point-to-point or interception of any conversation as it is taking place, if an enforcement officer approaches an ISP or any other device that captures the communications, then they can circumvent the law. And I think we can make an amendment to Section 2, just change a few words, and we can capture that. Yes. Well, let me repeat. I recall before the summer recess, I already explained that in the day-to-day investigation work of LEAs, the LEAs do request information from ISPs, both local ones and overseas ones, and the information includes the name of users, the IP address, and the address and the home address. And the purpose of seeking this information is to locate witnesses. The information doesn't include the content of communications. And the procedures carried out under the stringent regulation of the ordinance. As for the access records, etc., they will have to abide or comply strictly with the Personal Data Privacy Ordinance. Now, in terms of combating cybercrime such as child pornography or email scams, the LEAs will have to obtain information from the ISPs. And as they're doing so, definitely, they will have to comply strictly with the law. Mr. Kwok's question was whether you would consider making amendments. As explained before, I think the amendments that we're talking about should be within the scope of application of the bill. We so far do not see the need to make any amendments. But if Mr. Kwok has some suggestions, then we're happy to read his amendments. Well, Chairman, if that is the case, then we will propose our own amendments. Mr. James Toh. 2 points, Chairman. I think on Mr. Sin's request, let's say it's not done on a long-term purpose, but rather to have a snapshot of the situation. Say, for the 3-month period, The request was made in July, and you could have done it already. How much resources are you talking about? As a member of this council, or as a member of the public even, I can I may think that there is something suspicious here. Well, Mr. To, I hate to interject, but it's not the first time you raise this issue. You have been repeating your viewpoint again and again, and I think you have expressed yourself loud and clear, and the government has given a response. So if you continue to dwell on the same point, I mean, it's not a new point. Oh, Chairman, no. Because according to paragraph 9, it would make a disproportionate impact on the limited resources. Let me say it once again. Well, if they say that if statistics are kept in the long run, then there will be an impact. You're right, but what if it's only done on a 3-month basis? Chairman, allow me to finish. They're still refusing to do that. She said that it should be discussed on another occasion, but what's the difference between this and another occasion? Would there be any difference in terms of their establishment? No. Let's not forget that apart from lawmakers, you, as representatives of the Security Bureau, also need to oversee your subordinates, your LEAs. And you know nothing. You just have blind faith in them. And you are accountable officials because you're acting on behalf of the Bureau Chief, who is an accountable official. You need to have some basis to be accountable for you to believe in them, so that you can say loudly to members that, right, there is no problem. If an application for interception of communication is needed, then so be it. But you don't have any basis. So how can you exercise any supervision? Yes. Can it be done for a shorter period of time, a 3-month period, for example? Give us some statistics. Understood. Mr. To also made the same request last time. We went back and considered his request. We need to think carefully about what the 3-month period means, even without the problem of limited resources. Let's say if we get statistics from one of the LEAs within a 3-month period, then the set of statistics may not be the same for these 3 months than the next 3 months. It has to do with the cases involved or what stage of investigation it is in. Like I explained just now, they may only apply for a warrant towards the end of an investigation. Allow me to finish. So we need to consider how much help the statistics would give in helping us understand the issue. And as I explained, this is rather a nuisance because the LEA is already providing a lot of statistics to various stakeholders, the public, other public bodies, so on and so forth, and it's quite difficult to obtain statistics in a comprehensive manner. Well, but in terms of a certain division, then the figures won't be really huge. Let's say for the crime section, it will be shocking if you say that there are several hundred cases. So just tell us for a certain section how many cases there are in a focused manner. You really cannot convince us, convince the public. Rather, we suspect that you're just afraid of accusations of abuse of power. I have another question, Chairman. Well, Mr. Charles Wong just raised his hand, so I'll allow him to go first. Well, Chairman, I don't think I'll be able to extract more answers from them. I don't think I'll be lucky after what I heard from the answers given to other members' questions. We are still dwelling on the same point because of this. The Security Bureau of the government is unwilling to disclose statistics that can be kept easily, and one could only infer that these statistics must be embarrassing for them. And as a representative of the telecommunications industry, I must relay their concerns here. Over the years, they have been pestered by so many so-called requests from LEAs to obtain information, and they have no alternative but to follow the procedures. I don't want to repeat what I've said before. I don't know why the government would think that phone bugging would be included under this ordinance, but as for obtaining information from ISPs is regarded as collecting evidence. It's a nuisance to the industry. We're only asking for some basic information. And the industry thinks that it is very unfair to them. And we're concerned about possible abuse of power by the government and infringement on people's freedom on the net, and we have grave concerns.
The administration said that they will not ask for secret communications content. They will ask for open information, such as the domain, the login address, and so forth. But I can't really accept that this information doesn't form part of the content. In fact, it is part of the content. So you will not just the bill doesn't just regulate the access to the body of communication. In other countries, they have the same regulation over the access to metadata. But I think the administration has created its own definition so that they can have access to anything they want. During the summer break, I had the opportunity to read books, and I also read research studies conducted by privacy experts overseas. And according to the reading, well, even if you just have access to the metadata and not the content, you can have more information, because it said, I will know then people you have frequent communications with, and also the time you usually call him or them. So the spirit of the law is to protect the public. So it is utterly unacceptable that the administration continues to refuse to give us the information we seek. Well, for past information, you cannot provide it. You should have at least collected 2 months of information starting from July, and yet you've refused. Can you do it starting from tomorrow? You just asked the formation in charge to give you separate statistics, and Sin Chung Kai can do the adding up for you. Sin Chung Kai is willing to do it free of charge. I know I can more or less expect the answer, but I must express my dissatisfaction with the highly uncooperative attitude displayed by members of the administration here. Mr. James To. All right, I will let go para 3. lest the chairman will say that I'm repeating myself. But part 4, para 4, conduct that is necessary and incidental. Para 4 is about commissioner, the commissioner's power to listen to the products. Now, if the regional version is in a language not understood by the commissioner or his subordinate, I don't see anything in the bill to allow the same power to the commissioner under Section 30. Will the commissioner enjoy the same power under Section 30? That is, can the commissioner invoke Section 30? Or do you have a similar provision for the commissioner? Yes, I put the same question to our legal advisor. Yes. Thank you, Chairman. Does the commissioner enjoy the same right? Now, the commissioner doesn't have access to protected products, but in future, if he can do so and he comes across a language unknown to him, there are possibilities, because it is decided that the commissioner can have access to such products in the premises of the LEAs. Now, if there is any language difficulties, the LEA will arrange for internal staff to do the translation for him, feeling that so-called outsiders with confidential agreements and checks and balances will be employed. So the commissioner will make use of the translator of the LEA. We mentioned Section 59(1)(b) of the ordinance. Is about protection accorded to protected products, a subject of concern to members as well. It specifies that the head of an LEA must make arrangements. For instance, he should take feasible steps to ensure that the protected products are well protected and will not be used inadvertently, or will not be processed or deleted inadvertently. So when the commissioner is allowed to have access to such products, then the LEA has to ensure the integrity of the translator concerned. Legal advisor. Let me see if I have understood Mr. James Toe's question correctly. Mr. Toe's concern is if some protected products are not in a language familiar to the commissioner, then the translation services or the power enjoyed by the commissioner will not be one authorized for him. Rather, he will make use of the translation services of the LEA since the conduct will be done in the premises of the LEA. So can the administration clarify whether my understanding is correct? Thank you. Under Section 53(1)(a), the commissioner enjoys another power. The commissioner under the ordinance can require any public officer or any other person to answer any question that the commissioner may put to the person concerned within the time and the manner specified by him. So if the commissioner has to rely on the provision of a translator by the LEA, now the intercepted products have been translated by the translator in the first place. And then he is also asked to provide assistance to the commissioner. How can the commissioner discharge his duty of supervising the LEAs? Because I want to know whether in the bill there is any built-in power for the commissioner to employ his own expert. Of course, with a framework or system to ensure confidentiality so that the commissioner doesn't have to rely on the LEA. Under 53(1)(a, the commissioner has very wide powers. He can require any person to assist him for the discharge of duties. Of course, in actual practice, the commissioner have to give regard to the need for confidentiality. So I believe that the functions of the commissioner will not be checked by the LEAs. Now, Mrs. Ng, I think I have to correct you. When we talk about requiring any public officer, 1A require any public officer or any other person. But it's used as chairman. Because this any other person is not there to assist the commissioner. Rather, you're talking about any other person of the LEA. The commissioner will not ask the translator to answer this question, translator. And also a person who will have to provide any information, document, blah, 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 in his possession or control. Now, let me state my stance. I'm of the view that the commissioner should be able to find his own translator, and he should have the separate power to exercise this. You have to give him this incidental authority under the bill. You should not rely on Section 53(1)(a) and (b), because the requested party is in fact the administration or an object he has to supervise. I think the legal advisor understands me very correctly, right? This is not the whole purpose of the ordinance or the provision. Mr. Ken, regarding authority enjoyed by the commissioner, we may refer to Section 1 of Cap 1. For the commission of any act, it would have to be deemed to be reasonable, to be given reasonable authority for the commission of a certain act or discharge of certain duty. So if the commissioner thinks fit, he can require the assistance of any person, even without invoking Section 53(1)(a). No, Section 53(1)(a) is not really for that. Now, please do not rely on Chapter 1. You should give the commissioner powers as wide as that under Section 30. We rely on the commissioner to monitor the LEAs. So rather you move an amendment to add something similar to Section 30 for the commissioner here. Ms. Chu, I thank Mr. James Till's observation, but as mentioned by Mr. Kan, Cap 1 is clear enough. It is a reliable basis. It is a statutory underpinning already. So we do not see the need to amend the bill here. Besides, I think the amendment will be beyond the scope of our bill. How come? Well, even for LEAs, they do not just rely on Cap 1. You have given them Section 30. We are asking for a similar provision as Section 30 for the Commissioner, and you say that it is out of the scope of the bill. I want our legal advisor to confirm it. How can that be? It is the whole point of the bill. Legal advisor, we have to first read the actual provisions to say whether it is within the scope of the bill. But usually, in making a ruling, the President will look at the content of the bill, the legislative brief, and also all relevant factors. So what is the original objective of the bill?
That is, for example, an amendment to Section 53 to give further powers to the Commissioner. This will be the factors for consideration in approving CSAs to be proposed. So we need to look at the specific amendments. But in general, if we're talking about giving further powers to the Commissioner, then any related or incidental things should be included in the bill or not. This is subject to members' judgment. Anything to add? Thank you for your comment. Of course, from the perspective of the government, in terms of operational details, now the Commissioner will request for access to the protected products at the actual premises of the LEAs. And if there is any language barrier, a translator will be present. So we don't see the need to amend the legal framework. We respect the views of Mr. James Toh and the legal advisor. And it's up for the Bills Committee to decide whether they should propose amendments or not. But our position is this. But that's the crux of the problem. The Commissioner will have to use their translator. Now, about giving incidental powers to the Commissioner. This is actually giving the Commissioner a straitjacket. That is to say, the Commissioner should not engage his or her own translator. Instead, the LEA's translator should be sought. Well, if the Commissioner is not familiar with the language, then he could do nothing about it. This is giving the Commissioner a straitjacket, because access could only be made at the premises of the LEAs. And it's just like what happened to Mr. Wu. Well, Chairman, I think this is a major issue. It's not a matter of whether it's included in Chapter 1 or not. The whole design is to bind the hands of the Commissioner so that the Commissioner could only rely on a government translator. Otherwise, you should add to the Section 30. Chairman, I'd like to respond. I want to solemnly clarify here that in terms of the design of the bill, and even when the bill, before the bill was passed, before the ordinance was enacted, we had no intention of undermining the powers of the Commissioner. We want to give the Commissioner more powers to oversee the operations. We require the Commissioner to have access to intercept products at the premises concerned, so as to prevent any leak of information. This is a better arrangement that is more reassuring. And it's also of the Commissioner's own volition that this suggestion is floated. Then it is also in line with the design of the bill. While members may have their own observations, the government has also responded. And the legal advisor has given his interpretation. That is to say, the future Commissioner should have the right to engage his or her own translator instead of a government of one or one assigned by the government. I think this point has been expressed clearly. Chairman, I have a question. It's been some time since the beginning of some recess, and in July an incident happened right after the last meeting was adjourned. According to media reports, in early July, WikiLeaks discovered some emails of the hacking team of an international company, which show that the ICAC had approached the company concerned to ask for a demonstration of a remote control Galileo system, or Galileo remote control system. And I think this incident has to do with this bill. So I wrote to the ICAC requesting them to respond to a number of issues. The ICAC then, in an open statement, addressed some of these issues. The email was confirmed to be true. It came from a staff member with the surname Chair, and according to the ICAC, they would keep themselves up to date with the technology, and I agree with them. If according to the information from WikiLeaks, it's about getting new information, then I don't think there is a problem. But the ICAC has failed to address some of the issues concerned about the law, and I hope the government can respond to these issues now. I asked whether the ICAC is actually using the software, and they have not given me a direct answer. Another question was this: is the ICAC using any similar surveillance software in terms of interception of communication, and has any prescribed authorization been sought from any panel judge or the commissioner? According to the website's information, the software can allow circumvention of other procedures or other applications in the phone to obtain the actual content of data in the phone and to track the whereabouts of the user anytime, anywhere. And it can also circumvent any other firewalls or applications installed without affecting the functions of the phone or draining the battery of the phone. So let's say if somebody is using this software, well, of course, I don't think they will answer me whether the police or the ICAC is using this software. But even if it is the case, will they be required to seek advance approval from the panel judge? Because the difficulty is this: if the application is installed in my phone, then around the clock they'll be able to get data from my phone. Let's say if they have been given approval by the panel judge, then will they be able to trace me anywhere for my whole life? And I don't think you're going to undertake not to use this technology, because technology is constantly evolving. So I want to know whether this software is being used and what's the connection between the software and this bill. And subsequently, some reporters found from the WikiLeaks website that apart from ICAC, the police also communicated with this hacking team. And I later learned from the industry that apart from this hacking company, there are other companies in Europe, in the US, and in Korea focusing on this kind of technology. I don't know whether any LEA in Hong Kong is using this technology, or I want to know if indeed in the future this technology is used, whether this bill will apply. Well, it's a rather simple question. You don't need to talk in circles if you want an accurate answer. Well, DS, Chairman, let me respond to Mr. Mok's issues. Well, first of all, the government will not carry out any unauthorized covert operation. If interception of communications is involved in a covert operation, according to the ordinance that we're scrutinizing, or the bill that we're scrutinizing, authorization must be sought in advance. Well, of course, in the telecommunication system, I mean, in the interpretation section, there is a definition for that. And each LEA has the responsibility of reviewing their technology and facilities in their enforcement work. So they have this legal responsibility to keep themselves up to date as far as the technology deployed in enforcement is concerned, to ensure the efficiency of their or capability of enforcement. As to whether the software in question is being used by any law enforcement agency, now it relates to the technology that the LEA is adopting. If we say in public whether we are indeed using certain technology, then it will easily disclose the strategy adopted by the LEA. So we're not going to say that in public. But let me stress that if the technology is used in the course of interception of communications, if it's caught under the bill, if the circumstances are caught under the bill, then definitely it will be subject to the regulation of this ordinance. Mr. Sin, I want to ask another question, not about technology, but about the scope of the bill. My understanding is that this ordinance is about interception of or contemporaneous interception of communications. Now, according to what you said just now, the government will not carry out any unauthorized operation, but an authorization can easily be sought from, say, the police commissioner. So, setting aside the technology used, if an LEA is authorized to get certain information using that technology, then it will not be caught by this. Is that right? Is this a right conclusion? Whether it is regulated or not, according to Section 2(1), there is a definition for interception. It's in relation to any kind of communication or interception of this in communication. The communication may be transmitted in the course of a communication and examined by a third party or intercepted by a third party. I want to stress that the focus is on the act. My understanding is different from yours. According to your explanation, one is the transmitter, the other is the receiver, and then somebody intercepts in between, and this will be regulated by this ordinance. But let's say you want to intercept a piece of information sent from Mr. Charles Mok to me, then instead of intercepting in the middle, you only retrieve information from my side, instead of intercepting in the course of sending the information. Well, Mr. Sin, you already said many times this point on interception. Well, this is stemming from Mr. Charles Mok's question. Mr. Charles Mok talked about the technology reported in a news article. What if the LEA decides to use this software to get data from a person instead of intercepting communications between two? Mrs. Ng. Well, perhaps I'll supplement to address Mr. Sin's concerns. Apart from regulating interception of communications, a large part of this bill is about surveillance. So on whether the LEA can install a software or an app to put you under surveillance, then the ordinance clearly spells out that a device or an equipment should be used, and if there is a reason to suspect, if you don't know about the surveillance and it infringes on your privacy, then it's covert surveillance. So let's say if it's not about interception of communications, and if the LEA is putting somebody under surveillance without the person knowing it, and if this is carried out with the aid of an equipment or a device, then an authorization should be sought.
So I'm wrong, right? Doesn't matter. It's best that I'm wrong. So Mr. Mok talked about the use of such software for cover surveillance. I think that is subject to the regulation of the bill, right? Can you please say yes or no to this question? So if an LEA has to carry out a cover surveillance operation with the by means of some tools or device, then it's subject to regulation. What about a software? Can a software be regarded as a device? Well, you cannot use the software itself. It has to be through a device. No. For instance, I plant virus, Trojan virus, into your mobile phone, and as a result, data has been transmitted to my own mobile phone. So strictly speaking, I'm not using a particular device. I use a software. Is that software a device? First, the ordinance defines different data, including a data surveillance device. It is clearly defined in the bill. And as the DS said, we cannot comment on the technology used by LEAs. I haven't commented on it. Yes, I understand. Now, I'm a layman here, but my understanding is if you want to plant a certain virus software into the mobile phone next to record it next to me, I have to use a device, for instance, a computer, before I can do this. Okay, before I can do it. And the whole operation, the means, the conduct, and the use of the device, if it is cover surveillance, then everything is subject to supervision. Mr. Mok, according to Ms. Lee, the technology is secondary, and the conduct or the operation is the primary concern. But I think you use selectively invoke certain pieces of legislation, for instance, telecommunications and also the internet. I think you are exploiting the differences of between different technologies, and you apply the law selectively. And I think Mrs. Ng was really telling us that if a software like Galileo used by the hacking team is used by an LEA to put myself or any member of the public under surveillance, then it should be subject to regulation or supervision. The software, now a hypothetical scenario, a certain LEA use whatever means to plant that software into my mobile phone, which belongs to me. The software was downloaded by myself by trick or by whatever means. So this is the device. Although the device is not from the LEA has not planted a device into my shoe, or still the device plus the software makes it a cover surveillance operation. So I'd like to ask, because my question was not answered, can I take it that the question has been answered? Has the ICAC used any type of surveillance software for investigation? The administration is not going to answer this, but if such software has been used for cover surveillance, should the LEA get authorization, prior authorization under the ICSO? Can the administration confirm or say specifically, yes? I think I heard the answer. Well, to reiterate, if for the sake of combating crime or for safeguarding of public interest, an LEA has to carry out interception of communications or covert surveillance, it must be subject to regulation and supervision. So to answer Mr. Mock's question simply is yes. All right. Although you didn't say no, I think it's quite likely that the answer is yes. Anyway, all different limbs of the definition has to be fulfilled yet. Well, that's just a reply from the administration, not the ICAC. No, if it is the administration's interpretation or understanding, the ICAC has to follow it. Otherwise, it is pointless for the administration to answer so many of our questions here. I will take what the administration said here as proper, and all LEAs should follow, because the chairman said that it is up to the ICAC how it conducts itself. Just a small point. Whether both the software and device is subject to regulation, it is certainly yes, because if we look at Section 2, you have a definition for data surveillance device. It means any device or program used for cover surveillance. And of course, the ordinance regulates other types of device. So, DS, can you please once again clarify the answer from Mr. Charles Mock? That is the question about ICAC. Any LEA, including the ICAC, has the objective to prevent or to combat a serious crime for the sake of public safety, and if anything done falls into the definition of cover surveillance and interception of communications, then it has to follow the law. It has to be given authorization first. Now, if an LEA is investigating a case, and if it thinks that it is a serious crime, so on and so forth, it has to act according to the ordinance. What if the LEA thinks that it is not a serious crime, so it doesn't have to follow this ordinance? Instead, can it use such a tracking device or surveillance device to check somebody 24 hours around the clock. The LEA may say that this is just a suspect, and for whatever reasons, I have to put him under surveillance around the clock to monitor what he says and what he does. Is that right? Can that be allowed? Of course not. Otherwise, the ordinance would be meaningless. Dear Mrs. Ng, certainly this is not allowed. Under the ordinance, designated LEAs can do certain acts with authorization. It forbids any other public officer to do such things without authorization. In other words, everyone here, including legislators, are not allowed to do that. I think the answer is clear. Can we go to go back to our clause-by-clause scrutiny, page 4 of the marked-up copy, Mrs. Ng. Page 4. I said last time, Justice Wu, the commissioner, the then commissioner, wanted to allow the court to revoke in part an authorization. And so Clause 4 amends Section 3.1. In this ordinance, the conditions for the issue or renewal of a prescribed authorization that are in the circumstances of the particular case. Now we have added for the issue or renewal of a prescribed authorization or the continuance of a prescribed authorization or a part. This is just to put in place a recommendation by Justice Wu. All right, page 5, no amendment. Page 6, Section 23, confirmation of emergency authorization. Clause 5 and 7 are textual amendments just to rectify differences in the Chinese and English texts. 23.1 says that for application of confirmation of emergency authorization, the English version says that confirmation by the panel judge must be made within 48 hours, must be issued. Because the Chinese text says become valid, we have to amend this to say issue in Chinese, 发出. That is, application for confirmation must be done within 40 hours after the issue of an order. I don't see it in the English text, English marked-up copy of the bill. 23, issued. The word issued is used, whereas in Chinese, 生效, meaning takes effect or becomes effective. Sometimes an order may not take immediate effect. For instance, the authorization is now signed and issued, but the operation may start at midnight. So the panel judge, as soon as the panel judge or the administration has issued the authorization, then an application has to be done within 48 hours. Now, the original Chinese text would make it looser, so we have to rectify this by amending the Chinese text. Confirmation must be sought within 48 hours when the authorization was issued. I'd like to know whether you use the Chinese or the English text as the basis of enforcement. I believe they would use the term issued. Because according to the reports of commissioners, emergency authorization had never taken place, or confirmation of emergency authorization had never taken place. However, Justice Wu, the ex-commissioner, asked for this amendment quite a while ago. So all along, they've been using the tighter criterion, and that is 24 hours after an authorization was issued. Okay. Page 7. Section 24, determination of application for confirmation of emergency authorization. Mrs. Ng. Again, this is to put in place a recommendation by Justice Wu. When the panel judge consider or refuse to grant confirmation of emergency authorization, conditions may be imposed before the operation may proceed.
So under 24.3a2, we're adding the following. To be revoked or only to have the effect subject to variations and any new conditions specified by him from the time of the determination. That is to say, the commissioner can, or the panel judge can impose new conditions. And then we also add 3A. The new conditions specified by the panel judge may apply to the emergency authorization itself or to any further authorization under it, which is in line with other provisions, that is to set out the scope of the authorization. Mr. Sin, can you explain in detail the need for 3A? 3A. Now, if you read along with the provision, we're actually drawing reference from section 32 of the ordinance. In terms of renewal or issuance of prescribed authorization, news or conditions may be imposed on the authorization or to any further authorization. So this is just mirroring section 32 as to what further authorization means. In fact, when we discussed prescribed authorization in section 30 just now, there are incidental acts that may be permitted under the prescribed authorization. Mr. Sin, let me try to understand this. 3A is modeled on a previous provision. This is the new 3A, and this is pursuant to 3A2 above, because you have added any new conditions to 3A2. So what's the relevance of these two? Well, Mr. Sin is right. That's because we are adding these three words and any new conditions. We want to make sure that these new conditions can apply to the emergency authorization itself or to any further authorization under it. Now, as to what further authorization means, you may recall that we discussed section 30 just now on prescribed authorization. Prescribed authorization to certain acts and some incidental acts, including the use of force to gain entry to premises. So the authorization may apply, or the conditions may apply to the authorization and authorized act or the incidental acts. And that is why we must include this new provision. That is to say, the panel judge is given more powers to impose more restrictions or less, more. In Section 32, there is already a provision. When the panel judge approves a fresh application or renew an application, the panel judge may impose new conditions. The former commissioner opined that the panel judge doesn't have this right when he confirms an authorization. He only has the power to impose new conditions when approving or renewing an application. That is why we are proposing this amendment to provide for this power to specify new conditions when confirming an emergency authorization, and it may apply to the emergency authorization itself or to further authorization. So we're not binding the hands of the panel judge in any way. So put it in another way, what would happen? How would the panel judge handle it before this amendment bill? Well, it only applies in the case of authorization, but not emergency authorization. Chairman is right. In confirming the emergency authorization, the panel judge may amend the conditions. But it seems that he did not have the power to impose new conditions. So he may amend existing conditions, but there is no provision that allows him to specify new conditions. But as we explained, we have not encountered any cases of emergency authorization before. And this amendment is in line with the former commissioner's view. Mr. Sin. Well, I haven't read thoroughly the annual reports of the former commissioner. The provision was not invoked in the past because it was cumbersome for enforcement officers, or what? I mean, there is this section in the ordinance, except the new condition part. From Section 20 to 24, they relate to emergency authorization. Emergency authorization relates to interception of communications and surveillance. Emergency authorization is needed because the situation is imminent, and the officer may not be able to reach a panel judge for approval of application. In Section 20, we're talking about some serious scenarios, imminent or serious threat to property, or somebody's life is endangered, and that immediate interception of communications and surveillance is required, and yet the panel judge's approval cannot be sought immediately. Under such circumstances, the department head can grant an approval for an emergency authorization, but in the end, the panel judge's approval is required. So no such cases in the past? No such cases. There are 3 panel judges, as you understand. They have a roster system, and arrangements have been made such that even in the case of emergency, they can be, one of them can be reached. So even in the middle of the night, the panel judge will have to entertain the request. Is that right? As I understand, in the case of emergency, the officer may need to reach the panel judge at his or her home. Mr. Paul Chair, to pick up on Mr. Sin Chung Kai's question, I have this question. Before this amendment bill, normally, what conditions must be met before an emergency authorization is given? what provisions can we rely on? And then after review of the existing ordinance, new conditions can be imposed. And is there any connection with the existing conditions, or are there any restrictions? Mrs. Normally, when a panel judge confirms or approves an authorization, he may impose new conditions. These conditions are confidential. We have not taken part in the process. But from our experience, the new conditions may relate to some requirements. For example, where there are material changes in circumstances, a report should be made at once. It may have to do with legal privilege protection or new information discovered. Or perhaps the panel judge may be of the view that there is a high risk that sensitive information may be involved, and an officer of the inspectorate rank should be tasked to handle it instead of a junior rank and file. But since this is confidential, it's not disclosed in the Commission's report. I'm just quoting some general examples. So, Chairman, before the amendment, there is already a mechanism that protects the confidentiality of conditions. Then you can just rely on the existing mechanism instead of adding any new conditions. I wonder if this is gilding the lily, whether it is necessary to put in this addition and any new conditions. P.S. I think Mr. Chair's observation is sound. Section 32 of the ordinance covers issue and renewal of authorizations. And new conditions may be imposed when the authorization is issued or renewed. That is the existing position. However, in terms of oral or emergency authorization, the existing ordinance doesn't provide for new conditions to be added, and that is why we want to make it clear in this section. Because in the next section, we again would propose to add any new conditions in the scenario of an oral application. So we either change section 32 or change this part, and we've chosen to amend section 24 and 27 such that it would be more easily accessible to readers. Well, perhaps we're still not very clear about the link between section 24 and 32, but on reading section 32, I believe that the margin is wide enough without adding this bit and any new conditions. Of course, I am not in the operations. I may not understand their difficulties, but just by reading the law, I think it should be able to reflect the situation. I just want to know what actual difficulties officers have that leads to this addition. PAS. Section 32 has to do with the issue and renewal of authorization. And I believe when the former commissioner made the suggestion, he considered that new conditions may only be imposed in the case of issue or renewal of authorization, but not in confirming emergency authorization. That is why he made this suggestion. Mr. Sin Chung Kai, I want to ask from another perspective. On 3 capital A, of Section 24. Section 24 is about confirming the emergency authorization. And then 3A reads, may apply to the emergency authorization itself, which is fine, and then the following, or to any further authorization or requirement under it. To any further authorization under it, it means the emergency authorization itself, is that right? Please continue. The emergency authorization itself or any further authorization under it, which is a kind of prescribed authorization according to the ordinance. And I mentioned just now that Section 29 and Section 30 expressly provide for matters that may be authorized. In short, when a panel judge confirms an emergency authorization, he may impose new conditions or, pursuant to Section 30, impose new conditions that may apply to further authorization. Say, for example, the use of force to gain entry as an incidental act.
In the use of force, there may be new conditions applied. For instance, to ensure that minimum force is used. No. The crux of my question is now Section 24, 3, capital letter A. I understand that it can apply to the original authorization. The question is, you have got the phrase or requirement under it. I'd like to know what does it here refers. Any further authorization under an emergency authorization. Please allow me to assist Chairman. We are thinking of two concepts. A banner concept, a banner authorization. That's emergency authorization. Under it, there are two subsets, sub-authorizations. The main set is emergency authorization, and it contains the following elements: the valid period, the effective date, and the end time, the subject, the name, and the device used in that surveillance operation. You can call them terms or conditions in the emergency authorization or the main authorization. Should there be any material change in the situation, or if it is really expected that LLP legal privilege and also other things are involved, then under that banner, further authorization can be there. As Mrs. Ng said, under sections 29 and 30, we have details, and they're about invasive powers in a surveillance operation. For instance, interfere with the property, tamper with the property due to some reasonable need, or to gain entry into premises for authorized acts, and to remove or to retrieve a device from any article. So these are further authorizations, though they do not happen often, but they may be there depending on the circumstances. So either new conditions are to be attached to the emergency authorization or to add new conditions to the further authorization. In some cases, both may be required. Mr. Sin, if further doesn't mean a further period, but it's just ancillary conditions, why don't you use the term ancillary? Because further will give people, including Mr. Sin, the impression that after a certain period of time X, further authorization is an extension of time instead of ancillary conditions to be imposed. You may say, you may refer to the ancillary powers under sections 29 and 30. Well, we use the word further authorization, that is from section 32. Authorization may apply to the original authorization or a further authorization. So we just want to follow the wording in section 32. Now, if we are to amend as proposed, we may have to amend section 32 too. Ms. Hamley Lau, the DS said that when, for instance, when journalistic materials are expected, is this amendment as a result of problems encountered in the past to the effect that you want to be extra cautious? No, certainly not. The LEAs have always been very cautious when journalistic materials might be involved. So long as there is this heightened possibility, they would immediately report to the panel judge and wait for the panel judge to decide whether the surveillance operation can continue. Any authorization granted by the panel judge or the relevant authority would attach a lot of significance to journalistic materials. Now, for the relevant applicant, if they are aware of this possibility, they have to inform the panel judge. And the panel judge will certainly then impose conditions in case journalistic materials are really involved. The fact must be reported to the panel judge. You told us that the panel judge had to be informed when journalistic materials were involved. I'd like to know what conditions would usually be imposed by the panel judge. So has there been any case where the panel judge has rejected such an application because of the possible involvement of journalistic materials? Please speak into the microphone. LEAs tackles journalistic materials very cautiously, as said by the DS. For protection of journalistic materials, there are a few protective features in the bill. For instance, the Commissioner can have access to protected products. According to the former Commissioner, that will enhance protection for journalistic materials and legal privileged information. And if there is any material change in the middle of an operation, for instance, you suddenly hear that there is a greater possibility of obtaining material journalistic, then the final judge must be reported. We have put it in the bill to require the LEA to submit a report to the panel judge for him to decide whether the authorization should be revoked or varied or conditions imposed. My question is, no matter how much protection, whether you're going to enhance it or not, I'm asking whether the past a panel judge would always grant the authorization. I'm asking a question of fact. Chairman, we can go and check. In our impression, there were cases when such applications were rejected. Please don't use your impression. Go back and check whether it be LPP and JM. Please tell us whether those cases were always approved, because such cases are more sensitive. Please tell us the situation in the past and also amendments that involve such things in the bill. Can you please give us such information? Yes, Mr. Sin Chung Kai. Regarding 3A, Mr. Paul Jie made a proposal. Now, because the words in bracket says whether granted or imposed under its terms or any provision of this ordinance. It says here, when the panel judge refuses to confirm the emergency authorizations, blah, blah, blah. And here it says the new conditions specified by the panel judge under subsection 3A2 may apply to the emergency authorization itself or to any further authorization requirements under it. You're referring to a further authorization under section 29. Would it be more reader-friendly if you add under section 29 here? Because I was thinking perhaps you meant further authorization to the emergency authorization. All right, we'll think about this. Members, do we have further questions on page 7? Can we go on to page 8, section 26, confirmation, again to rectify the differences between the English and Chinese texts. Originally it says what 續期生效後, meaning when the renewal takes effect, we have amended it to 發出或該續期批予, that is the issuance of the extension of the renewal. All right, I'll ask the same question. Before this amendment, what was the basis for your enforcement? Did you go by the English text or the Chinese text? As far as I know, the LEAs follow the English text as the basis for their enforcement of their practice. That is to use the tighter requirement. That is within 40 hours after the issuance of the renewal or authorization. All right, we'll start with page 10 next time. Prior to that, we will go through information to be provided by the administration as requested by members. So we'll start from marked up copy, page 10 of the Chinese text next time. So the meeting ends here. Date of the next meeting is the 12th of October, Monday at 10:45. Thank you very much.